Well, there are
I'm just
cases.
asking you to explain to me why having to prove you are who you say you are before you vote doesn't serve, you said it doesn't serve any legitimate state interest. I'm just asking to explain that stuff.
All right, everyone, get ready. What you're about to see is one of the most tense and memorable exchanges from a Senate Judiciary Committee hearing. In this clip, Senator John Kennedy is doing what he's known for, asking direct, plain-spoken questions and pressing for straightforward answers. The nominee in the hot seat is Nancy Abudu, who at the time was being considered for a lifetime appointment to the U.S. Court of Appeals for the 11th Circuit. Before her nomination, Abudu served as a senior attorney with the Southern Poverty Law Center. During the hearing, Senator Kennedy focuses on her past positions and writings, particularly on issues related to voting laws and election security. His goal is to determine whether she views certain election integrity measures as discriminatory. As the questioning unfolds, Kennedy keeps pressing for clear yes or no responses. Abudu's answers, however, are more nuanced and carefully framed, leading to a back and forth that quickly becomes one of the most talked about moments of the hearing. Let's take a look at how the exchange plays out.
Is the selective incorporation doctrine?
That also, in the voting rights or civil rights context, is a term that I haven't had to come across. But what I do know is that as a legal research and writer, and for sure confronting possibly new areas of law, I look very forward to doing my due diligence in terms of making sure I'm familiar with doctrines such as that one.
Do you know what it is?
So no, I'm not familiar with it sitting here
Selective
today with
incorporation
you.
doctrine? Okay. Well, you're going to see a lot of it if you're confirmed on the 11th Circuit. Can Congress pass any law that the Constitution doesn't prohibit?
Based on the frame of your question, I would say yes, that sounds right.
So you think Congress has plenary power?
Well, I would first look to what the Supreme Court has said in terms of following precedent.
No, but I'm interested, if I could, Counselor, in your opinion, does the United States Congress have delegated powers or plenary power?
Well, the Congress has both, I would say, from my general understanding. Again, it depends on the context and the issue, but
Okay.
it is.
Can you explain the difference to me between strict scrutiny and intermediate scrutiny?
Senator, strict scrutiny is the highest level of scrutiny that's often applied in constitutional cases.
What's the definition? I'm sorry, go ahead. Excuse me.
So it requires that a state, when enacting a law or regulation, have a compelling governmental interest for doing so, and that the law is narrowly tailored to achieve that interest.
Okay.
And then intermediate, did you?
Yeah.
Okay, so intermediate speaks to the issue of having a substantial interest or or an important governmental interest that is substantially related.
Okay. Do you believe that the meaning of the Constitution is immutable, or does it change over time?
Senator, I would say that the Supreme Court in some cases has analyzed that issue, and the response really does depend on the context and the issue. But what the court does or has done in its approach, of course, is look to the plain meaning of a statute or of the Constitution, because that really is where the inquiry should start. And if the language is plain, then that is where the inquiry can end.
Okay, thank you for that. You were involved in a 2021 report from the Southern Poverty Law Center about voting in Louisiana. Did you say, quote, racist white Southerners, close quote, and, quote, hostile white voters and governmental officials in Louisiana continue to make local polling places and early voting locations threatening spaces for black voters? Did you say that?
Senator, I do not believe that I said that. I haven't read that publication in
Will
some
you help
time.
write it?
I helped to draft the publication and approved it, but I'm not familiar with that
Oh,
language.
you don't, okay. In that same report, did you say, well, tell me where in Louisiana local polling places and early voting locations are threatening African-American voters? You said it, so which polling places?
So again, Senator, obviously I don't have that report in front of me to be able to read and remind myself of the examples that might have been shared. But what I can say is that Louisiana.
Let me cut you off because I'm going to run out of time, Counselor. Let me ask you one more. In August 2021, we're not talking 20 years ago, we're talking 2021, you were involved in another report by the SPLC. And you said that voter identification, photo ID to vote, is burdensome and does not serve any legitimate state interest. Do you really believe that?
Senator, identification for voting is
Yes, but
something.
first, do you really believe that? You said it. You meant it?
The Supreme Court in Crawford v. Marion County has already upheld voter ID laws as per se
Yeah, but you said it didn't serve any legitimate state interest. Do you believe that?
Again, Senator, without that language in front of me, it's hard to understand
You
the
said it.
context.
Here it is, August 2021.
Well, there are
I'm just
cases.
asking you to explain to me why having to prove you are who you say you are before you vote doesn't serve, you said it doesn't serve any legitimate state interest. I'm just asking to explain.
Are you serious? Did we just witness a textbook example of the classic Washington sidestep? Senator John Kennedy comes in with what many people would consider straightforward questions. He asks whether requiring a photo ID to vote amounts to voter suppression. On its face, that sounds like a simple yes or no issue. But instead of giving a direct personal view, Nancy Abudu pivots to discussing legal precedent and the role of a judge. Her position, essentially, is that as a judicial nominee, she can't offer personal opinions on issues that could come before the court. Critics see that as evasive, a refusal to answer plainly. Supporters would argue that it reflects the standard approach nominees take to avoid prejudging potential cases. Kennedy presses further, including on the question of whether requiring proof of U.S. citizenship to vote constitutes suppression. Again, Abudu declines to frame her response in personal or political terms, instead emphasizing the legal framework and the limits of what she can comment on. For those watching, the exchange became a Rorschach test. Some saw a nominee carefully adhering to judicial norms. Others saw someone unwilling to clearly distance herself from past advocacy positions, including work at the Southern Poverty Law Center, where she had previously criticized certain voting laws. By the end, Kennedy appeared visibly frustrated, reflecting a broader tension in confirmation hearings. Senators often seek clarity on a nominee's philosophy, while nominees typically avoid definitive answers to protect the appearance of impartiality. So what did you see? A cautious jurist respecting the boundaries of a future judge, or an advocate struggling to reconcile past activism with present neutrality?